the Evolution Security Podcast.
All right, everyone, we'd like to welcome you to the Evolution Security Podcast. We've got the Tactical Twins here. I'm Aaron Davis and my brother Eric Davis. How you doing, brother?
Man, I'm doing great, man. As always, it's great to see you on the FaceTime here, man. It's almost like we get to hang out, huh?
Yes, it's great. Now, our buddy Brian is not here. You know, I believe he is on a secret mission. And Eric, you know what I heard? He found 2 pallets of 9mm ammo at 19 cents a round. Did you hear about that?
Man, I didn't, man. I guess I need to go talk to him about that because I didn't get any of that.
Well, Eric, I have a confession to make. That was just a cruel joke. So, brother, you and our audience members don't try and hunt Brian down to get that deal because we all know that is a dream source these days. So, well, we have another awesome guest. His name is Andrew Branca from the Law of Self-Defense. He is one of the nation's, if not the nation's, premier legal expert on self-defense law. All right, before we go into the interview with Andrew, Eric, I'd like to talk about Origin. Their website is originmaine.com. Now, they are an all-American company that makes Brazilian Jiu-Jitsu gear, clothing, and supplements. It's crafted in America, built to work, and made for life. Now, Eric, I'm pretty excited. I placed an order the other day for a new rash guard, a cool new, if anyone's seen it on their website, the Chokes and Bones rash guard.
Yeah, I dig that rash guard.
Yeah, and then I've got some of their blacked out spats coming. I've got that gear now, but I've kind of worn it out. So I've got another Origin rash guard, but again, I've worn it so much, it's time to replace it. So also, I've got a couple of cases of that Jocko Discipline Go drink. I've got one case of the Sour Apple Sniper, which is the signature drink of our last guest, J.P. Donnell. And then I've got another case of the Afterburner Orange, which is Dave Burke's signature energy drink. Now, also, he is at Echelon Front. Maybe one of these days we can have him on too, Eric.
Yeah, it'd be awesome, man. I did not realize that flavor was out there. I guess I didn't pay attention too much, but man, it sounds awesome. I was going to grab a case myself.
Yeah, I guess he was a Top Gun pilot, so that'd be
that'd
be
not
awesome
just Top
to hear
Gun,
about.
Not just Top Gun pilot. He's a Top Gun instructor.
Oh, that's cool
as well. Yeah,
awesome,
really cool.
Well, we would just like to urge you to go and check out their website. Again, that's originmaine.com. They have got a lot of stuff to check out. And if you find anything you want on there at checkout, go ahead and enter EVOSEC10. That's EVOSEC 10. And that'll get you 10% off at checkout. So go check them out.
Awesome, brother. And I have to admit, man, it's been incredible being able to be at my jiu-jitsu gym again and wearing my Origin gis, man. It's I always get comments. It's like, man, that gi feels nice. I'm like, yep, it is. Let me know. We can hook you up. So I always tell them about the code. So thanks for sharing that, Aaron. So I'm going to go ahead and talk about Tenacore. Go ahead and visit them at tenacore.com and check them out. Again, we like to support people that train. They know what they're doing when they build gear. Tenacore is primarily a holster company, but I want to really hit on the fact that they just don't build equipment. They're a mindset, tactics, and skill company as well. Jeff Mao there, the president of that company, it gets out there. I've been at multiple classes over the years with Jeff, and those guys get after it for sure. But I wanted to emphasize, Jeff's an accomplished instructor himself in pistol and rifle, so on and so forth, a former SWAT officer. So he knows what gear has to do to work. So go ahead and check them out. Look at their Velo 4. I just used the Velo 4 this weekend. Had a lot of people ask me about it at the Range Master Pistol Instructor Development course, which we'll talk about here later in the show during our accountability. I plan on getting one of the Kurtums. I keep saying I'm going to do it. I'm going to go ahead and pull the trigger on that. And again, if you guys want to check out some of their holsters, you can use EvoSec at checkout for 10% off. So go out there and support them.
Yeah, great gear. Great gear.
Okay, ladies and gentlemen, now we'd like to talk about asking for your support in sharing and spreading the word about our show. We talk about this pretty often, and definitely not to sound like charity cases by any stretch. It's just that we are a firearms and self-defense company and show that unfortunately gets suppressed a lot of times on the main platforms. If anybody out there knows about some of the political censorship, well, we get censored on these platforms. They even deleted our ad capabilities on both Facebook and Instagram. So I'd like you guys, if you don't mind, go out there, and if you get something out of this show, share it with one family member and share it with one friend. Just do that for us. One in your family, one in your friendship circle. It helps our show grow. And speaking of social media, we've opened a Parler account. And we would like you guys, if you don't mind going over and getting an account on Parler. They do not censor folks like us and other firearms companies. So we want to support a platform that does that. It's a little bit like Twitter. There's some aspects of it that are different, but we're going to start doing a lot of stuff over there, and hopefully that helps us spread the word. So what do you think, Aaron?
Yeah, that sounds great. I'm looking forward to getting involved over there because, as we know, the censorship over, at least on Facebook, has become really ridiculous. Don't want to get into politics, but it's disheartening what they've been able to do. But real quick, so also want to remind you that if you could go ahead and go out to iTunes and give us a rating. We are currently at a 5-star rating, but we would like to keep that up. And once you do that, please take a little bit of time and give us some feedback. We really appreciate that. If you've got any suggestions for guests or suggestions that how we can improve, we would really appreciate that. So without further ado, Eric, you want to get into this interview?
Aaron, actually, before we do that, I'm just going to make sure that we have our email out there, crew@evosec.org. If you got any of those suggestions, go ahead and hit us up there, okay?
Well, all right then. So let's go ahead and get into this awesome interview.
Let's do it. Hey, we'd like to welcome Andrew Branca of the Law of Self-Defense to the show. How are you doing, Andrew?
Very well. Very pleased to be here. Thanks for inviting me.
Well, I'll first say that we had Masad Ayub on our show a while back. Of course, he spoke very highly of you, but the point being is that you're our first lawyer and especially a lawyer that focuses on self-defense law. So this is a new chapter in our podcast. So we really appreciate you coming on the show.
Well, it's my pleasure. And frankly, I wouldn't even be in this career but for Mas Ayub. When I first met Mas, I was a very young attorney, fresh out of law school, just passed the bar exam a couple years prior. And I took what Mas then called his LFI 1 course. It's currently what he calls his MAG 40 course. And that course focused largely on self-defense and legal aspects of self-defense. And it blew my mind. I had not been taught any of that in law school. And it led me to do primary research on self-defense law myself to really learn this stuff at a very in-depth level and build as far as I know, I'm the only attorney in the country that does nothing but use of force law exclusively. And I have to give Moss tremendous credit for setting me on that path. Plus, he was nice enough to write the foreword to the current edition of my book, appropriately enough, entitled "The Law of Self-Defense." And everyone always tells me he says nice things about me, and I really appreciate it.
Well, yeah, the foreword is an awesome tribute to you. So that's awesome, and frankly, Moss has influenced so many people over the years. So it's very cool that he happens to be the reason you're doing what you're doing. So very cool. Well, with that said, you kind of hit a little bit on your bio, but just go ahead and give us another 2 or 3 minutes of what you're about.
Sure. Well, long before I was an attorney, I was a member of the gun community, so to speak. I started competitive shooting as a kid, shooting small bore rifle, all through high school. Was believe it or not, my high school, even though I went to high school in New York metropolitan area of New York City. We had a rifle team at my high school, so I was on that rifle team, made all state shooting small bore rifle. As an adult, I moved into handgun competitive shooting, first USPSA and then IDPA. In fact, I played a very modest role in the founding of IDPA. My member number is 13, and I believe they have over 25,000 members now. So I was there very, very early in the process, helped edit the first rule book when the rule book was about 8 pages long, which is clearly not anymore to any of those of you familiar with the IDPA rule book in its current form. So shot competitively for many, many years on a national level. Shot, I think, the first 5 or 6 IDPA nationals. RO'd most of those. I was an IDPA, I guess they call them safety officers now. Before they had any kind of safety officer certification process, they would just take those of us who were USPSA certified to be range officers and give us an SO hat in IDPA. And of course, they've long since formalized that safety officer process now, as they well should. But anyway, so I'm a competitive shooter, active member of the gun community. And then I went to law school, came out, passed the bar, and I would go to gun matches and gun shows and gun stores and overhear people giving each other advice, legal advice on what to do in the unfortunate event that they had to use force to defend themselves, defend their family, defend their property. And the advice they were giving was horrific. It was the kind of thing like, if you shoot someone outside your house, make sure you drag them inside the house before you call the police.
No.
The kind of conduct that could turn what might have been a perfectly lawful use of defensive force into something that looks to cops, to a prosecutor, to a judge, to a jury, exactly like manslaughter. So I would explain to them why they definitely don't want to do that. And they'd say, okay, I get it. We understand. You explained it really well. But what's a resource people like us can go to learn what the actual law of self-defense is, as opposed to what our cop buddy might have told us, or the lawyer who did our house closing, or what we read in the gun magazine someplace, or these days, heaven forbid, learned off the internet, off Facebook or some internet gun forum. And unfortunately, there wasn't any good resource. When I went to learn this stuff myself, I had to do primary legal research, read the statutes, court decisions, jury instructions. There was no available book I could turn to that summarized all that for me. So I wrote that book because it wasn't available, and I wrote it for the gun community. Back in, I believe it was 1998 was the first edition of the Law of Self-Defense. Currently, we're into the 3rd edition of that book. And ever since I wrote that book, my legal career has really been focused exclusively on use of force law. So I have a very unusual legal practice. I don't have a generalized criminal defense practice. I don't do DWIs or shoplifting cases, or the only cases I do are use of force cases, period. And I also don't take clients directly. All my clients are other attorneys. So I'm basically a legal consultant to other attorneys who are the lead counsel for their clients on their cases. And my clients are those other attorneys. And the nice thing about that is it allows me to work on self-defense cases all over the country, whereas most attorneys, they're only licensed in one state. They take clients directly in that state, usually just from a small portion of the state, some region around wherever their office is located. And most attorneys tell me in their entire careers, 30-year career, they've had maybe 4 or 5 good guy cases of self-defense in that entire time. And it's very difficult to develop expertise in anything if you only do it 4 or 5 times over 30 years. So the nice part about the nature of my law practice is I get to work on use of force cases all the time, all over the country, without having to be a member of the bar in every state, because my client's just another attorney. I'm not providing legal services to the general public.
Well, Andrew, one of the things that I'd like to comment on, and I was going to ask a couple of other questions about your book, but you've kind of covered on some of the premise that I was going to ask a question. So I'll just say this for our audience out there, and I'm going to tell on myself. Aaron and I, and Brian as well, we came from a competitive shooting background as well, primarily IDPA, USPSA stuff as well. But we were also heavily into the combatives community. As I mentioned before to you, we're heavy trainers under Craig Douglas. And as far as training with him, multiple alumni under him. So we've met that piece very solidly. But we have not, I would say, been as heavily into the legal side. So that's one of the reasons why, number one, I bought your book. Number two, we've been paying attention to you online and learning from you. You've been on American Warrior Society several times. And frankly, that's just incredible information. But for our audience out there, if you are not taking the legal side of self-defense seriously, you could very much be in a heap of trouble not having prior preparation in this. And I do not know of another source that is better than the law of self-defense. So thank you very much for putting that out there, Andrew. It's an incredible book.
Well, that's very kind of you. You mentioned Greg Douglas. I'm a huge Greg Douglas fan. He does fantastic work. And of course, the work he does is infinitely harder than the work I do. The physical combatives part of the equation. There's really 2 fights we're talking about, right? There's the physical fight and the legal fight that happens after the physical fight. And I'll be the first to say the top priority has to be winning that physical fight. If you don't win the physical fight, everything else becomes rather less pressing. But having won the physical fight, you don't want to win it in such a way that you end up effectively spending the rest of your life in prison, which is where obviously I come in with law of self-defense. The good news is that at least the black letter law, the technical law that governs the rules of engagement for defense of yourself and your family, other people, is pretty straightforward. There's only 5 elements, 5 conditions that have to be met for your use of defensive force to be lawful. There's not 500 elements. There's not 50. There's only 5. Sometimes there's not even 5. There's really up to 5. Often one or more of those conditions is not required in that jurisdiction or under particular circumstances. But the most you ever have to worry about is 5. So that's pretty straightforward. Unfortunately, where things get complicated is not so much the law, but reality, the complicated, messy world of physical combat, and applying those 5 conditions to that messy, real world situation can become challenging. And that's where we come in at Law of Self-Defense to try to educate people about how those legal principles are actually applied to real people in real confrontations in the real world in real courtrooms, so they can get a practical and actionable sense of how the law of self-defense is likely to apply to them if they're in the unfortunate position where they've been compelled to use force to defend themselves, defend their family, defend their property.
Well, Andrew, that brings us to a question that kind of gets deeper into what you just spoke about. There is definitely common assumptions that if you have a cut and dry, lethal force use, that you're not going to end up having any criminal charges or even having any legal proceedings. But isn't that fairly common, or at least more common than people know?
The way I'd put it is this. It's the analogy I would use is smoking. So if you smoke, and years ago when I was young and foolish, I used to smoke. I was a pack-a-day smoker. I think we all know that virtually everyone who gets lung cancer is a smoker. It's almost impossible to get lung cancer if you're not a smoker. That said, it's also true that only about 8%, 10% of smokers ever get lung cancer. So 90% of them never get lung cancer. The analogy to the self-defense situation is that most people, good guys acting in self-defense, probably won't face criminal charges. But you don't know if you're going to be in that 10%. And if you're in that 10%, then the risk is 100% to you. Now you're being charged. And the possible consequences of being pushed into that criminal justice pipeline is potentially spending the rest of your life in prison. So I would caution people to not take the position that they're going to be prepared only for what might happen if the authorities are feeling favorably disposed to them, because that's not their decision to make. The moment you get in that physical confrontation, you've incurred not only a greater than zero risk of dying in that criminal confrontation, you've incurred a greater than zero risk of spending the rest of your life in prison. And when you think about it, when we prepare to defend ourselves physically, we don't prepare to defend ourselves against an armed robber who's going to stop if we ask him politely. We prepare for the confrontation where we're compelled to fight for our lives. Well, in the context of the legal fight, we can't prepare ourselves only for the legal fight that might go easy on us if the authorities decide to cut us a break or not bring charges, because it's totally at their discretion whether or not they charge you. We have to be prepared for the situation in which the authorities want to charge us, want to prosecute us, want to convict us, and want us to get sentenced to prison for the rest of our lives, because that's a real possibility every time. So that's the fight, the legal fight that we have to be prepared for.
Now, Andrew, what about maybe not even criminal prosecution, but the fact that you may still have to go through some sort of intermediate legal proceedings, like I don't know if it would be a grand jury, but at least a long drawn out interview process after the case, and then you still may need legal counsel, or more than likely you should have legal counsel for that, right?
Yeah, absolutely. You need legal counsel, and especially if there's been any kind of deadly force involved, even just a threat of deadly force. And by that, I mean even just making someone else aware that you have a gun and are prepared to use it, not even necessarily having shown the gun, much less pointed the gun or fired the gun. The moment you make someone else aware that you have a gun and you're prepared to use it for purposes of changing their behavior, which is the very definition of what we do in self-defense, right? We're trying to change that apparent threat's behavior by dissuading their aggression, by letting them know we're prepared to defend ourselves. Well, that's also the criminal definition of aggravated assault. You're putting someone else in fear of imminent death or serious bodily harm. Well, you can justify that conduct as lawful self-defense, but the way the legal defense of self-defense works is it always follows a criminal charge. So what happens is the prosecutor first says, well, you just put someone in imminent fear of death or serious bodily injury. That's the elements of aggravated assault, felony aggravated assault with a firearm, which in most jurisdictions is good for 10 to 20 years in prison. So clearly a life-changing sentence. Sure, you can try to justify that as self-defense. Let's do it at trial. Well, if you're going to trial on a felony charge, you better look forward to spending several tens of thousands of dollars. In fact, the most common case I consult on are aggravated assault with a weapons cases. And almost every case we consult on, we're able to get the charges dismissed. And I'm very proud of that. We have a very high success record. But that still costs that client a lot of money. A typical retainer for an aggravated assault with a weapon charge is $30,000 to $50,000 for the lead attorney. And that's for pretrial expense. That's not for going to trial. That's what you pay if we manage to get the charges dismissed, so you don't have to go to trial. If you actually end up going to trial, just double or triple that amount. So the monetary cost, even if you win, and I'm defining win as getting the charges dismissed or getting an acquittal at trial so you're not going to prison for 10 or 20 years, just the financial cost alone is horribly destructive. Most people don't have $50,000 or $100,000 or $150,000 just sitting in a box that they can spend on legal expenses just in case they have to defend themselves or their family.
Well, Andrew, if I can double down on your book, and the reason I'm going to put this out there now is that I'm going to put in the show notes a couple of links both to your law self-defense shop and even just an Amazon link to your book to kind of frame this, if I can say it this way, and you can correct me if it can be said better. Essentially, Andrew provides the reader the capabilities and the understanding how to articulate your innocence, and it does an extremely, I don't know if I would call it abridged, because it is quite a decent lengthy book, but I think it's so important for the audience to know up front that, hey, just reading the book and, kind of following up on some of the drills that you prescribe in it could very well be the biggest factor in keeping you from having charges against you from being questioned, correct? I mean, am I wrong in that? Because that's one of the premises of the book, right?
Well, a couple things I would say. One is I probably just scared the poop out of a bunch of people by talking about how serious the consequences can be if you use force against another person, find yourself criminally charged, being prosecuted, the kind of prison sentences. That's all true. I'm certainly not taking any of that back. But there's also good news. And the good news is if you do keep your conduct in self-defense within the legal boundaries, you can, in fact, make yourself extremely hard to convict. The law of self-defense, as I said earlier, is not that complicated. Where most people get in trouble is they don't know where the actual legal boundaries are. They step over those legal boundaries out of ignorance. And I don't mean that in a derogatory sense. I mean that in a technical sense. They literally don't know where the legal boundaries actually were. And if you do that, if you use force outside those legal boundaries, well, then it's not lawful self-defense. But if you can stay within those legal boundaries, and the only way to do that is to know where they are, but if you can stay within those legal boundaries, then the prosecution's in a position where they have to disprove your claim of self-defense beyond a reasonable doubt, which is a very difficult threshold if you've stayed within those legal boundaries. So it is quite possible to use force to defend yourself, defend your family, even use deadly force to defend yourself, defend your family, and still be very hard to convict. But you have to have stayed within those legal boundaries. And that's the purpose of our book, of our courses, of our blogging, is to inform people, not just in a theoretical legal sense, but by applying the law to real world situations, to give people an actionable sense of where those legal boundaries are. Because if you do stay within them, I can't promise you won't get prosecuted. We see bad prosecutions happen. We see politically motivated prosecutions happen. But I can promise you that we can make you extremely hard to convict by enabling you to make well-informed self-defense decisions that stay within those legal boundaries.
Well, Andrew, this brings up the aspect of legal defense service memberships, as you call them. Even if there's not question of the self-defense aspect that you did actually meet those criteria, you still promote the use of these service memberships. Now, how would you convince listeners, and I'll be honest, myself, the importance of being a member of one of those services?
Yeah, so I think it's actually a little more subtle than that. I wouldn't say that I advocate for people to get a membership in a legal service membership, what many people call self-defense insurance programs, because everyone's circumstances are different. And it doesn't make sense for everybody. For example, if I personally were in a financial situation where I had to choose between having my only pistol and enough ammo to practice with, or having self-defense insurance, I'd get the pistol. I wouldn't get the self-defense insurance. I need the pistol first because surviving the physical fight is the priority, is more important. But for some people, their circumstances, their life circumstances, their financial circumstances are such that they don't have to make that choice. So they've got the gun, they've got the training, they've got what they need within their grasp to be positioned to win the physical fight. So then we can begin to focus more on the legal fight. And as I said, the legal fight gets really expensive really fast. So if you don't have a ton of money stored away for that purpose, for funding a legal defense so you can fight that legal battle the way you want to fight it, which is as if your life depended on it, because it really does if you're looking at 10 or 20 years in prison. Then these organizations, these quote-unquote self-defense insurance organizations, can play a very useful role because they can provide that financial backing. I mean, generally speaking, what they promise to do for their members is pay the members' legal expenses of the members involved in a use of force event. Now, they all vary. They all have conditions and exclusions, and some of them have limits on how much they cover and so forth. So I don't want to dive into all those details. It would be too time-consuming. I just would urge people to make sure they know what they're buying, make sure they know what they're paying for, read the fine print. For me personally, I've looked at all these programs, as you might imagine, just as part of my job, my work for the law and self-defense community. I found that CCW Safe is one of these organizations that they're the best fit for me personally. That doesn't mean they're the best fit for you or anybody else. People have to make their own decisions, but I think they're worth considering. Another good organization is the Armed Citizen Legal Defense Network. Mas Ayub, who we spoke about earlier, is on their board of directors. Tom Givens, Tom Farnham, Dennis Tuller. Their board of directors is just simply world-class panel of expertise on use of force. So I certainly think they're worth considering. There's a couple other organizations out there that I don't feel I can currently recommend as a serious consideration, but they may be a good fit for any particular individual out there. So people have to make their own decisions. But again, the advantage of these organizations is that they can provide that kind of financial backing that you really need if you're facing serious felony charges following a use of force event.
Well, Andrew, one of the things that I really like about you online, both your website, the interviews I've heard you participate in, and in your book as well, is, again, you described earlier, you came from a shooting background before you even got involved in law. So that causes you to have a background where you're recommending people have proper awareness, avoidance, verbalization, de-escalation skills of the such. One of the most favorite sections of your book is the section on cognitive conditioning. Can you hit on what that is and kind of explain the importance of that? Sure.
So it's simply part of being a human being that when we're under stress, particularly life-threatening stress that our brain, the lizard part of our brain, is telling us could end our existence on Earth, that stress consumes an enormous proportion of our mental bandwidth, our ability to think through and make decisions. And I've had this experience myself. I've never been in a life or death fight. But when I was much younger, I temporarily lost my mind and decided I would learn how to skydive. And so I went to skydiving school, and I had an interesting experience where, you gear up and you get to shoot on and you get on the plane with everybody else, and the plane starts gaining altitude up to 13,500 feet. And the higher that plane got, the smaller my brain got. I could almost feel my brain shrinking until when it was time for me to jump out that door. If you had asked me what my name was, I don't think I could have told you. That's how scared I was. If you had asked me what 1 + 1 was, I don't think I would have been able to tell you. The only thing I was able to do was actually just screw up the willpower to throw myself out that stupid door. But that's what happens under stress. There was a part of my brain that was convinced I was going to die, and it really debilitated my ability to make decisions. We see this very commonly when we do live classes, which we don't do too many of anymore, but we've done hundreds and hundreds of them in the past. We would often bring a very high-tech shooting simulator with us from TI Outdoors simulation company, $20,000 simulator system. And we would run the class through the simulator. So they'd sit through a whole day of a law of self-defense course, and then we'd run them through the simulator where they'd see a little video threat, and they had an infrared laser pistol, a fake gun, and they had to solve the problem of the threat. And of course, it's totally artificial. It's a projected image on a screen, and if they decide to shoot, it goes click, 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 and it scores their imaginary hits on the target and so forth. And the video only lasts 30 seconds, 45 seconds, 60 seconds, something like that. And once they were done, quote unquote, solving the problem, We'd stop the simulation. We'd have them turn their back to the screen and explain to the rest of the class what they saw, what they did, and why they did it. And they couldn't do that because of the stress. I mean, literally, you could see their hands shaking. Their respiration was obviously increased. They couldn't tell us what they saw. There were obvious things on the screen that they never recognized, or they saw things that didn't actually exist. The rest of the class knew, for example, that the bad guy was not wearing a hat at all, much less a blue hat. They couldn't remember what they did, or if they remembered what they did, they couldn't remember the sequence or the timing in which they did it. We'd ask them, well, when did you draw your gun? And they'd say, oh, when I saw the knife. But we all saw them draw the gun the minute the video started.
Wow.
So in their mind, they didn't recall it that way. And it's not because they're lying. It's because the way the brain captures and stores and recalls information under stress is completely different than our normal experience. It's why police officers, for example, when they're involved in a use of force event, aren't required to give a formal statement for 24, 48, 72 hours after the event, because in effect, they're being given an opportunity for all those brain chemicals, all that adrenaline to drain out of their cognitive function so they can give a coherent narrative of what happened. Otherwise, if you took a story from someone involved in the use of force event 5 minutes after the event and an hour and 12 hours and 48 hours and 72 hours, you'd get a different version of the narrative each time, not because they were deliberately changing anything or lying, but just because their brain was recalling different things at different intervals. I've had police who've been involved in shootings tell me years later, they suddenly remember some facet of that shooting that their brain had completely blocked out up to that time. So how the brain works is really complicated. And one consequence of this stress consuming so much mental bandwidth and our brains operating in such a different way when we're under stress is it tends to degrade the quality of our decision-making. We don't tend to make better decisions under stress. We tend to make worse decisions under stress. And if you make bad decisions in a use of force event and you end up falling outside the legal boundaries, well, then you've got a real problem because it becomes very difficult. Instead of being hard to convict, you've made yourself easy to convict. And that's not a good place to be. So what do we do about that situation? Well, one thing you can do is, to some degree, immunize yourself against the stress. And I don't mean go out and get in a bunch of gunfights. Obviously, that would be counterproductive. But there are things you can do in life that induce some modest level of stress while still tasking you with doing many of the activities, many of the steps, many of the functions you would be doing in self-defense. And a great example of this is competitive shooting. If you're an active, engaged competitive shooter, over time, with experience, the first few times you shoot, you're nervous, your hands are shaking. There's so many things to think of. Safe gun handling, doing reloads, moving from one position to another while still keeping the gun safe, all that jazz. But after a few years, all that becomes completely subconsciously competent conduct. You don't need to think about it at all. You're just doing everything safely the way it needs to be done. And the part of your brain that used to be consumed with doing an efficient reload of the gun, for example, doesn't need to think about that process anymore. It's now free to do things like execute your stage plan or whatever the case may be. Well, in real world activities, if you're actually in a fight, that part of your brain is now free to think about the fight, to observe the aggressor, to make better decisions, because that brainwidth is not consumed about, all right, these are the 4 steps of how to present a pistol. You're not thinking about that anymore because you don't have to think about that anymore. That's an automatic activity. And by making as much of that automatic as possible, you free up those portions of your brain to make better decisions. And the great thing about competitive shooting is it's a fun and productive way of immunizing yourself against some of that stress you'd otherwise be experiencing in a real-life confrontation.
Well, and if I can also add to that, Eric here again, and I was I am an Army veteran, but I didn't do anything sexy, nothing like SF or combat arms or anything like that. Minor stress downrange, but I would say that ECQC, the first time I took that course, I could not remember half of what took place. And I think that's why I emphasize the importance of both your suggestions of cognitive conditioning and scenario-based training, because it does get easier after several times of taking that course. I started remembering everything. And then the last few courses I've taken, I remember everything. And I'm not saying I made perfect decisions, or I'm not saying I won every scenario either, but I made better decisions. And I think that's why we should, really emphasize the importance of that.
It's almost like your brain got bigger, right? You see more, you feel more, you sense more, and you just generally make better decisions because you've been exposed to it repetitively. I love the ECQC stuff. I think it's the best possible training you can get for a real life self-defense encounter, because you are actually doing it. Other people are putting their hands on you. They're resisting your efforts to defend yourself in a totally safe environment, of course. But you're actually going through the physical motions against the resistance of another human being. And I don't know of any better way to learn that stuff than the way Greg does it.
Well, and quite frankly, our audience may get tired of hearing about it all the time, but we're going to keep pushing that, or at least that type of training, because it is deeply important. And again, another aspect of keeping you out of legal trouble. So with that said, Aaron, what you got, brother?
Yeah, I have a couple of questions here, but I want to first start with what would be some, actually you mentioned one earlier, but what would be some common myths regarding self-defense and force use that often get people in trouble, even if they won the fight?
Yeah, so one of the most common questions I get actually is, what are the most, people say, Andrew, what are the most common ways that people mess up a claim of self-defense? You say there's 5 elements, and for folks who don't know, those elements are innocence, eminence, proportionality, avoidance, and reasonableness. Of those 5 elements, which one is the most commonly messed up, or which 2 are the most commonly messed up? And I wish I could answer that question directly, but all I can say is, man, people mess all of them up, every single one. In a variety of ways. They let themselves get goaded into a confrontation that didn't have to happen. For example, they become a mutual combatant. As a result, they lose that element of innocence. They lose self-defense. They are facing a genuine threat, but maybe a threat that's not yet imminent, not yet immediately about to happen, and they begin to use defensive force before the threat is imminent. Or they use defensive force after the threat's over, the other person's walking away. They lose that element of imminence. They lose self-defense. Proportionality is a common one, especially with people who get a concealed carry permit. And by the way, folks, I'm a Second Amendment absolutist. I consider virtually every gun law applied preemptively to law-abiding, mentally sound American citizens to be unconstitutional, period. So I'm all for people who want to and are law-abiding and mentally sound carrying guns for personal protection. I've carried a gun for personal protection my entire adult life. I expect I will for the remainder of my adult life, hopefully a long time to come. But unfortunately, a lot of people get that concealed carry permit, get that gun, strap it on their hip, and they think they're now prepared for violent encounters that may occur in their lives because they have the gun. The gun is their hammer, and they have a tendency to see every problem as a nail. But unfortunately, as great it is to have a gun on your person, because if there's a problem that only a gun can solve, well, then you really do need that gun. If you look at FBI Department of Justice statistics, you're 5 times more likely to be facing a simple assault or a simple battery, a non-deadly force threat, against which a gun's not an appropriate response, than you are to be facing a deadly force threat. And a lot of times, the only defensive tool people have is that gun on their hip. And when they feel threatened, they go to the gun. It's a natural reaction. Unfortunately, often when they go to the gun, it's under circumstances in which a gun is not actually the legal appropriate response. Empty hand defense, BJJ, martial arts may be appropriate. Yeah. Pepper spray may be appropriate. Lots of appropriate options. But under those circumstances that they're facing, it needs to be a non-deadly defensive force option and not a gun. So they go to the gun. The most common cases I work on are people in exactly that situation. They go to the gun and they get charged with aggravated assault with a weapon good for 10 to 20 years in prison. And they can't believe they're getting charged for self-defense because in their mind, they have a genuine good faith belief that they were acting in necessary self-defense. But again, they were ignorant of where the legal boundaries actually were. They stepped over them. And once you step over those boundaries, as hard to convict as you are inside those boundaries, you are extremely easy to convict outside those boundaries. So once they stepped over those boundaries, they're in real trouble. The fourth element of the 5 that I mentioned is avoidance. This has to do with whether or not your state has a duty to retreat. And there where people get into trouble is they think, hey, I'm in a stand your ground state. Most states, 3/4 of states are stand your ground states. Therefore, I don't have a legal duty to retreat. Well, that's not quite true, actually. Most stand your ground states, stand your ground is conditional. There are certain conditions that you have to meet to qualify for that privilege of stand your ground. And it's not that hard to violate one of those conditions. And then you don't have the privilege to stand your ground. You've lost that privilege. And once you've lost it, you've once again acquired a legal duty to retreat, if safely possible, before you can use force in self-defense. And if you don't do that, well, then you don't qualify for self-defense. And if you happen to be in one of the 1/4 of states that are duty to retreat states, well, then it's an absolute requirement of self-defense law that you retreat if safely possible before you use force in self-defense. And the last one is reasonableness, the last of the 5 elements. And that's really where this diminished bandwidth for making decisions occurs. Excuse me. It's where people begin, they have the best of intentions, but they begin to make poor decisions because of the stress. They begin to make unreasonable decisions. And if you're making unreasonable decisions, if your perceptions, your decisions, your actions in self-defense are unreasonable, well, then they don't qualify as lawful self-defense. And of course, whether or not any of that was reasonable is not your decision, right? It's not your judgment of what's reasonable that determines the legal outcome in your case. It's the judgment of police and prosecutors and judges and jurors, people other than you, whose judgment of whether or not your perceptions, decisions, and actions were reasonable controls the legal outcome of your case. So really, of those 5 elements, again, there's only 5, but it's quite possible for the well-intentioned, normally law-abiding person, generally out of stress and ignorance, to violate one or more of them. And here's a trick with self-defense, folks. Although there's only up to those 5 elements of self-defense, they are cumulative. So they're all required. A prosecutor does not have to disprove your claim of self-defense in its entirety beyond a reasonable doubt. He only has to disprove any one of the required elements, any one of them, beyond a reasonable doubt. If he does that, it's like breaking the link in a chain. It doesn't really matter which link is broken. You break any one of them, the chain is broken. If he disproves any one of those required elements beyond a reasonable doubt, it doesn't just diminish your claim of self-defense. It obliterates your claim of self-defense. What you did was not, as a strictly technical legal matter, self-defense, cannot be legally justified.
Let's assume, unfortunately, that a person gets to the point to where they are in this terrible event and need to use deadly force. And let's even assume we know that it's a good use of force. But do you have a basic list of, steps, actions, responses to police officers, and then going back to the very beginning, starting with the 911 call?
Well, it's something, how to interact with the police in the aftermath of a use of force event is something that we spend a lot of time thinking about and teaching about, but it's very difficult to give a short answer. In our live class, it's about a 7-hour class, or what we call our Law of Self-Defense Advanced course. We spend at least a full hour of that day just on interacting with the police in the aftermath of a use of force event, because it's more complicated than most people think. For one thing, you don't just have one kind of police interaction. You have at least 3 different kinds of police interaction. You have the 911 call, you have the responding officers, and then you have the investigative officers, the detectives. Generally, these are all 3 different people. And how you interact with each of them is different for a variety of reasons that would take an hour to discuss. So in that sense, it's more complicated. It's also more complicated, I think, in the sense that many people will have heard, for example, hey, if you have to use force in self-defense and the cops show up, just say nothing. Don't say anything to the police at all. If you say nothing, then, well, nothing that you said can be used against you, right? Because you didn't say anything. And that's not an entirely illegitimate position to take. It's very true. If you haven't said anything, there's nothing to be used against you. But it's also true that if you don't say anything, you could leave really important value on the table, value that's important to your legal defense. For example, if you don't point out evidence, if you don't point out your attacker's weapon or witnesses who were present to observe what actually happened, there's nothing that says the responding officers are going to find that weapon or find those witnesses. And if that weapon or witnesses disappear, you could have a serious problem because that weapon is the reason you shot that guy. And if it disappears, if it's not in evidence, it doesn't exist for legal purposes. And there goes your reason for why you shot the guy. So that can greatly damage your legal defense. So what we urge people to consider is an alternative to the say nothing approach. And that is what we call the say little approach. Little things like identify that evidence, identify those witnesses, a few specific things. But again, in our live class, we spent an hour going over all this. So it's difficult to capture in just a few moments. I will say this, though. The say little approach that we suggest people consider is not for everybody. People have to decide for themselves because it's very important that if you're going to say those specific things, that you say only those specific things. If you start blathering, that's bad for you. You do not want to be doing that at all. So if your choices, your real world options, based on your personality, how you respond to stress, is not reasonably expected to be, I can say a few things and stop, but rather your real world options are say literally nothing or blather, well, then you have to say nothing. You can't be blathering away. Now, we all respond differently to stress. We should, as adults, have some sense of how we respond to stress. And of course, we can all think this through ahead of time, and we should before we're actually involved in a use of force event. So I think different people will come to different decisions about what works best for them based on their personality, their ability to handle stress and still constrain their behavior. But it is, I think, a lot more complicated than simply say nothing. For one thing, the people who say, well, just say nothing, that's easy, right? Nothing more to think about than that. Well, are they telling you not to call 911 if you've shot somebody? Because if you don't, that can look very bad indeed. That doesn't look like self-defense anymore. But if you do call 911, are you going to dial the numbers 911 and then say nothing? I mean, that doesn't make any sense, right? You're going to say something. And the moment you say something, guess what? You are talking to the police. You're not saying nothing anymore. So it is, I think, important for people to really think through this ahead of time. And by the way, not just for themselves. So this is something we run into all the time, is we have cases where somebody's had to defend themselves. Maybe they've been through my course. Maybe they've been through Mas Ayoub's course. They've thought through what they might want to say to the police or not say to the police in the aftermath of a use of force event. But guess what? This happened while they were in the company of family members, for example. They had a wife with them. And the wife's never thought about what she should say to the police or not say to the police. But guess what? She's a witness, and the police are going to talk to her. So unless she's given thought to what this might be like as well, that's a pretty big gap in your preparation for interacting with law enforcement in the aftermath of a use of force event.
Well, that's very, very important suggestions for sure, Andrew.
Wow. Yeah. I haven't thought about that myself very much. Thank you.
And Andrew.
And by the way, sometimes what the wife has to say is not helpful.
I'm sure in many cases you've dealt with that. Andrew, one of the things I'd like to hit on that you mentioned before and kind of double down on, because in many cases, having physical capabilities, empty hand capabilities, could keep you out of all of this that we're discussing, other than you may still have to face determining if your use of empty hand skills was warranted as well. But yeah, we're big advocates. We all train in jiu-jitsu and certainly push that on this show heavily. With that said, let's talk about your online classes. One thing specifically, you every Thursday you have a Q&A. Correct me if I'm wrong. That's free, correct?
It's free. So every Thursday, 4 p.m. Eastern time, we do what we call our Law Self-Defense news and Q&A show. So people can send us questions in ahead of time. They can just email them to us at show@lawselfdefense.com, or they can join us for the live show and ask questions during the show. And that live show airs simultaneously for our Law Self-Defense members. Most of our Law Self-Defense content is restricted to members, but not this particular Thursday show. But it broadcasts to our members through their member dashboard. It broadcasts live on our Facebook page, which is just facebook.com/law of self-defense. And it also broadcasts live simultaneously on our YouTube channel, which is just youtube.com/law of self-defense. So people can watch the show live on any of those. And if they want to ask a question in the comments, we'll do our best to answer the question within the time limits available. We try to keep the show to just an hour out of respect to everybody's time. But that's the one piece of content we produce every week that is open access. You don't need to be a paying member to participate in that Thursday, 4 p.m. Eastern Time news and Q&A show. So we certainly encourage people to take advantage of that opportunity. If they can't make the live show because of their schedule, we do leave a recording of the show, essentially a replay of the show, up on Facebook, on our blog, lawselfdefense.com/blog, and on YouTube. But I have to say, we don't monitor the recording for people asking questions after the fact. We just don't have time for that. So if they want to ask questions, they need to either email them in for consideration or ask them live during the show. But if they can't make the show, they can still access the content in the replay mode on Facebook or our blog or on YouTube.
Well, and Andrew, you also have a lot of other, of course it is for members, but can you hit on your other online classes? Because you also said that you aren't doing as much live events, so you're doing a lot more online content, correct?
Right. So for many years, I was doing maybe 50 travel classes a year, traveling all over the country, and frankly, it just got to be too much. So about 2 years ago, we started really cutting back on that tremendously, and then of course COVID hit, which gutted travel schedules anyway. And we don't have any plans to go back to a heavy travel schedule again. Since then, what we've done is we've produced versions of the equivalent of our in-person class on DVD, online streamed. So there's other ways for people to access that content. Those are courses that people would purchase. We also have a Law Self-Defense membership where just about every day we produce content, plain English legal analysis. I mean, not dissimilar to what your audience is hearing in this podcast interview. So this is independent of that free Thursday show that's open access. But most of our blog content and all our blog content is produced as video, audio, and a written podcast. So you can consume it in whatever medium you find most efficient for you. Our podcast is exclusively members only. So you do have to be a Law Self-Defense member to get access to the podcast. But you also get access to all those really hundreds of hours of our accumulated blog post videos and podcast content when you become a member. And membership's dirt cheap. It's under $10 a month. I think it's $9.95 a month, so about 30 cents a day. And people can try it out for 2 weeks for 99 cents. If they go to lawselfdefense.com/trial, they can sign up for a trial membership, 99 cents. No obligation. If you want to cancel within that 2-week period, we'll give you 200% of your money back. Granted, that's only 99 cents extra back to you, but we didn't ask for much up front. And the point is we try to make it a negative risk opportunity to encourage people to give it a shot. And we almost never have people not stay a member just because staying a member is so inexpensive. And by staying a member, they get almost daily access to that new content we produce almost every day. Analysis of use of force events in the news. We write extensively about cases like the Kyle Rittenhouse case, the George Floyd case, any high profile case you see in the news. We cover in detail any interesting appellate court decisions from around the country on use of force events. And all of this, by the way, it's translated into plain English. That's really the value we try to deliver to the Law Self-Defense community, is translating all the legalese into plain English so it's understandable and actionable for people. So it's useful for them if they're in the moment having to survive that physical fight and needing to do it in a way that the don't simply end up going to prison for the rest of their life. So again, I would encourage people to certainly enjoy our Thursday show. That's free. There's zero obligation there. It's open access. And also I would encourage people let's face it, it's not much of a commitment. It's 99 cents for a 2-week trial membership. And you're obviously free to cancel at any time. And that's at lawofselfdefense.com/trial. And I think if they do try it out, they'll stay a member because really virtually everybody does.
Well, and I would tell you that, of course, having purchased your book and that being some of my primary education of your work and then the podcast, I'll commit to you that I'll get on there as well. Because, there's no reason why, at a minimum, we shouldn't be doing the Q&As, but also supporting you and what you're putting into the community that can keep people a lot safer from going to jail and many other aspects, including the defense side. So yeah, that's certainly something that I'm going to commit to as well, Andrew.
Yeah, and one thing I would urge people to consider too is there's always been a certain number of prosecutions that I've seen that didn't look like they were prosecutions based on legal merit. They looked like they were politically motivated. Perhaps the most famous one in the use of force realm was the George Zimmerman case. But I'm seeing those kinds of politically motivated cases more and more and more frequently. The Kyle Rittenhouse case is a great example. The McCloskey case in St. Louis is another example where there's really no legal merit to these prosecutions at all. And as far as I can tell, the prosecutor's not actually doing it for the purpose of getting a conviction. If they get a conviction, they'll be ecstatic, of course. But really, they're doing it for political purposes, to generate political capital, to use the legal process itself as a punishment, even if they don't think they can get a conviction at the end of the process. And the legal process is a punishment. Make no mistake about it. Yes. It's life-destroying. So the days when you could have a reasonable hope that, hey, you're a law-abiding person, you've never been in trouble with the law before, you had to defend yourself, maybe you kind of blurred the line a little bit about your use of force, but you're a good person, the prosecutor will cut you a break. Man, you just cannot count on that anymore because there's no way to know if that prosecutor who gets assigned to your case feels that they can get political capital from bringing your case to trial, that it'll satisfy some part of their political constituency, that it'll line them up to run for state attorney general or governor or whatever. It's to their advantage personally and politically to bring you to trial, even though the prospects of getting you convicted could be close to zero, because that's not what they care about. They're not doing it for purposes of legal merit. They're doing it for political purposes. And if you want to survive that fight, you really need to have been within the legal boundaries. Now, if you were within the legal boundaries, they might still force you to have that fight, and that's destructive. But if you stayed within the legal boundaries, the prospects they can get you convicted, we can get as close to zero as possible. So you may get prosecuted. That's no fun. But it's way better to get prosecuted and acquitted than prosecuted and convicted. So all the more important in this world we live in today, where there's so many politically motivated prosecutors, to make absolutely sure you know where those legal boundaries are and you stay within them, because you cannot count on a prosecutor making decisions out of the kindness of their hearts in your favor.
Well, it's definitely made us livid recently seeing these charges brought against. You mentioned Kyle and then also the McCloskeys. It is amazing to me seeing the political motivation, and that kind of segues into another. Honestly, it may be a can of worms, and I'm not sure if you're really into answering this question. Maybe you asked this before, but I'm sitting here, I'm looking at one of my new favorite builds, and that's a AR pistol in 300 blackout. And there's been a lot of back and forth, the ATF coming in with letters essentially going back and forth on whether or not the pistol braces are legal. With that said, what are your thoughts on the legal risk if you use one of these new modern AR pistols in self-defense? Is there some liabilities there? Because you're thinking about, what if I incidentally use the brace on my shoulder? What if, any other political motivation that might come about? What are your thoughts on the legal risk?
Right. So I should I just want to make clear to the audience up front, my area of expertise is use of force law. It's not weapons law, gun law. So that's a very different realm. So how the ATF is likely to treat arm braces, for example, I don't claim any more expertise in that subject than any other typical American gun owner who has his share of ARs and all that jazz. I can certainly recommend attorneys who have great expertise in that area. I'm not it. I do suspect on a personal level that much of what we're seeing out of this from the ATF at the moment are decisions being made by what might be called deep swamp creatures within the ATF who are trying to cause trouble for Trump. So they're coming out with these, suggestions, hints, threats of action, so that people on places like Facebook and Twitter can say, "Hey, all you can, pro-2 amendment people, look, Trump's not saving you. He's not doing you any favors," to discourage people from thinking of Trump in favorable terms. It's quite possible after the election, and I'm certainly presuming and hoping that Trump gets reelected, that all this will go away, will magically be cured. So, but that's, of course, my personal perspective, not an expert legal perspective. We'll have to see what happens of all that. Let's assume for purposes of discussion that it's absolutely determined that all these pistols that so many people have made, these AR pistols with an arm brace on it, are overnight become illegal. And let's imagine that possession of them, if they're not registered with the $200 stamp or whatever is required, becomes a felony. What's that do to you if you use one of those weapons in self-defense? Say there's an intruder in your home, you shoot the intruder with that weapon. What will typically happen is that the fact that you did it with that gun in most states won't impact your claim of self-defense at all. Your claim of self-defense is going to be evaluated on its own merits. What could happen, however, is that your use of force might be perfectly lawful in terms of the 5 elements of a claim of self-defense, but you're separately charged with a gun offense for the weapon. And you're on the hook for that. So you could be totally clear on the use of force. You shot the intruder, totally justified, no criminal liability for that, but now you face criminal prosecution and liability for being in possession of an unlawful weapon. That's entirely possible. There are a few states, not many, but there are a few states, and Georgia's one of them, for example, that they do condition self-defense on not being engaged in unlawful activity, usually felony level unlawful activity. If you're in one of those states and you use an illegal gun to defend yourself and possession of the gun has been made a felony, well, then you do jeopardize your claim of self-defense because merely being in possession of the gun is felony conduct. And if self-defense is conditioned on not being engaged in a felony, well, then you've jeopardized your claim of self-defense. Now, when they make the law like that, when they say, well, we don't want self-defense to be available for people engaged in a felony, what the legislators were actually thinking about was, well, we don't want someone engaged in armed robbery to be able to claim self-defense, right? Or someone committing a rape to claim self-defense. I mean, that would be ridiculous. But unfortunately, the way they word the statute, it could leave you vulnerable to losing self-defense because of this, possession of what would have been made into an unlawful weapon. But a lot of that is speculative, right? We don't know whether it's actually going to be unlawful. We don't know what the criminal sanction will be if it is unlawful. So all I can really do is discuss the whole matter in kind of a hypothetical sense, the way I just did.
Sure. And frankly, we do hope that Trump gets reelected and the ATF stops with this silliness, because, I mean, in what real realm does the difference between a regular AR and a pistol? Yeah, I mean, you can say they're easier to, carry in bags, so on and so forth. But the reality of the low usage in any shootings of ARs of any type, it's just silliness. And I certainly hope it goes away, because they are also very effective defensive tools.
Yeah, they certainly are. And but you have to keep in mind that these gun control laws, as applied preemptively to law-abiding American, mentally sound Americans, are never rationally based. There's no rational basis for any of them. That's why they're all facially unconstitutional. They don't reduce crime. They don't do anything that they purport to accomplish. They're made for purely emotional reasons to placate the percentage of the voting public that responds to those emotional appeals. Hey, bad guys would never shoot anybody if we only made guns illegal. Well, first of all, they still have their guns. They're not turning their guns in. Second of all, even if you could make all their guns disappear, well, they'll just start stabbing people. I mean, that's what happens in the UK, for example. So you don't change bad people's behavior by taking guns away from good people. And, any simpleton ought to be able to see that. But these decisions are not being made on a rational basis. They're being made on an emotional basis. So the only thing you can really do to solve this problem is to take away the power from the people making these rules on this emotional basis. That may mean firing a bunch of people at ATF, which would be awesome.
Totally agreed. Okay, so let's go ahead and move into, we're going to start closing out the show here in a second, Andrew. What I'd like to ask you right now is, what does your current self-defense training look like right now?
Right. So I guess I would best characterize my current preparation for physical self-defense as being in maintenance mode. So as I said earlier, I've been a competitive shooter my whole life. I have a very strong foundation in handling a firearm. Most of my competitive experience is with pistols in practical shooting sports. When I lived in New England, I had the very fortunate opportunity, because I was an adjunct instructor at the Sig Sauer Academy for, obviously, self-defense law. Basically, I had an open invitation to every class they offered, which were mostly at the time, especially technically limited to law enforcement and military personnel. And as you might imagine, I took advantage of that opportunity to the greatest extent possible. Yeah. So I like to, stay in my lane and just do, when I speak publicly, the legal aspects of use of force law. But for a small town lawyer, I've had an exceptional amount of training and experience in the defensive use of firearms from a training perspective. So I don't feel much like I need to improve on that aspect of it. So I'm really kind of in maintenance mode. I won't say I'm at 100% of where I was when I was a very active competitive shooter. I was a master level competitive shooter in IDPA, for example. But I'm probably about 80% of that level. And I just don't have the time to invest more energy into that aspect of my self-defense now. So I've just made the decision to settle for that 80% of the peak I was at when I was 10 or 15 years younger. And much the same goes for the non-gun aspects of self-defense as well, I should say.
Well, then, Andrew, this is Aaron here, and I'm just going to go ahead and ask, before we close out, the most important question on our show, which is, what are your 3 favorite bands and or musicians?
Oh, let's see. That would be a tough one. I know it's going to sound like I'm saying this just because it was in the news, but I went through high school in the early 80s, and my favorite band, certainly at the time, and those things tend to stick with you as you get older, was Van Halen.
Nice. Yeah.
So I was a huge fan of Van Halen, mostly the David Lee Roth era. By the time the Sammy Hagar years came along, I was more detached, more focused on my studies than on music. But they were certainly huge. After that, it becomes difficult. There's a great many bands I like. I'd have to say Led Zeppelin would be a key one. AC/DC would be a key one. Those would probably be the top 3 for me.
Well, as a rock guitar player myself, that is a very good list. Love it. Well, Andrew, we really appreciate your time coming on. This has been amazingly instructive and informative. So, again, we would just like to thank you for coming on and taking your time. It's been an honor.
It's my pleasure, gentlemen. Happy to do it.
Well, Andrew, thank you very much for myself, Eric, here, and we would certainly like to have you back on another time if you're willing to get deeper in some of these subjects. But like I said, we're going to commit to providing you more of our time on your show, on your online classes, because we need more of it ourselves. So we're going to commit to that.
That sounds awesome.
Well, you have a blessed evening. Until next time, take care, Andrew.
Thanks, gentlemen. Bye-bye.
All right, Eric. That was an enjoyable interview with Andrew Branca. It was great for him to share his amazing knowledge with us. But it is time for our accountability. You want to jump into it, brother?
Yeah, let's do it, man.
Well, I'll go ahead and start us out. So this week I hit 2 JIT sessions. I usually plan on
Awesome.
3, but I missed one because I actually had to go to the range. At least I was getting some work done. But and beyond that, I went a couple of times with my wife to the gym to get a couple of good cardio workouts in. I'm hitting the elliptical and the rowing machine pretty hard, and getting my resting heart rate down again. It kind of started creeping up there. Now, for dry fire, I have not been good about doing that every day, but I think this week I got that in about 4 times, and I'm usually going about 10, 15 minutes pretty hard. Actually, just right before we came in here to record, I did 50 draws from concealment using my Velo 4. And, just nice, smooth draws, not even pulling the trigger, catching that sight as it comes up, and then I'm getting a perfect sight picture. So now to the drill of the week. I have a confession to make, Eric. I think you do too, but
Yep.
I was not able to do the drill because when I went to the range this week, I could not get a 50-yard bay. Now, here's some interesting news, Eric. So I've got a really good range here in Tulsa.
It's an awesome range.
And it usually fairly busy, but in the last year, of course, with all this stuff going on, just like with the quadruple demand for ammo, there is quadruple demand for range space. That's awesome, but until you show up and you want a 50-yard bay and you can't get one. But that's all right. I'm going to get out and try and do that before our next show. But what I did do, I got there and worked on the 5x5, which is the classifier for IDPA. I just worked the 4 to the body, 1 to the head, which has kind of been my nemesis. You got to be real careful if you're running hot under time constraints. If you miss that headshot, that's 5 seconds added to your time. That can ruin your run there.
Oh, absolutely.
So I started out at 5 yards and again, just really focusing on that front sight and resisting the urge to go back and forth between my sight and the target, trying to see where I'm hitting. I mean, that's just a bad habit, and you end up, with looser groups there. So I started out at 5 yards, got real comfortable, and then I went out to 10 yards. And after one miss, I started nailing that, and for the rest of the time that I was running that, I was shooting it clean. So I went away feeling good about that. And then one last thing, I had a good friend again. I think he went to I talked about him going to the range with me last time. My buddy Justin, who's a new gun owner, and man, he's got some innate skills. He's shooting really well right off the bat. I'm proud of him. But towards the end, I wanted to show him probably the most important skill set, which is to get that concealment draw within about 5 yards under 2 seconds. So out cold on that, I went 1.38 seconds, which I'm really glad about that, and that's where
nice.
I would like to hang out for myself. But then I slowed it down, trying to show Justin about where he would want to be to get that goal moving. And it's funny, I could not slow it down past about 1.63, but that's all right. That in itself is a good solid time. So,
absolutely.
But yeah, I went away from the range like I did last time, feeling pretty good about my performance. So I think that is it for me this week, bro.
Awesome, man. That's some good accountability, brother. Man,
Thank you.
I dig hearing you going to so much jiu-jitsu, man. That joys my heart, man.
Oh man, I'm enjoying it. Been working at home with my wife too. I'm grabbing the mats and And again, if anyone knows, there's Gracie's system is a curriculum, and the first major test that you do is the combatives belt that sets you up to get your blue belt eventually, not too long after that. But it's going through, I think it's about 33 main techniques, and it's a lot to remember. So if I'm just working real hard on that, and I'm feeling a lot better about it. I think I might be ready to test pretty soon.
Man, awesome, man! I can't wait to hear that accountability. Well, as far as my jiu-jitsu goes, the last few weeks I've been real consistent with our gym opening. Been learning a lot, feeling that groove, getting back. This last week, however, I only got to go to one class because they're only having Tuesday, Thursday, and Saturday classes right now for the adults. And part of my other portion of accountability was that I traveled to Arizona for the Range Master Pistol Instructor Development course. So I'll talk about that in a second. But that made it to where I only got to go to one class, but had an excellent learning opportunity there with Professor Will at Jiu-Jitsu Dynamics. A little shout out there. Unfortunately, though, a little bad news. Our tyrant of a governor, Jay Inslee, decided that he was going to lock down our state again. So my gym shut down again. So
man,
I won't be able to train there the rest of the time I'm here. I'm moving. My wife and I are moving to North Carolina. So that's the last time I got to train there. Unfortunately, I don't want to be too negative. It's an incredible place. That's just the way things go.
Eric,
Luckily,
can you at least work with Ryan until you leave?
Oh, absolutely.
Good deal.
Yeah, he and I were texting back and forth last night, and we're just going to train together. I still get my jits in with him, and which he's an incredible instructor in his own right. So not that big of a deal. I just would have liked to have been under Will's help as well, but that's the way it goes. I also only had one workout here at the house because of travel, and it's the way the week shook out. My basic strength and conditioning. Worked a lot of chin-ups that workout. I just kind of focused on that and some rowing sprints, and then got my range session, my last range session in prior to the class this last weekend. But that's kind of my big accountability. I went and took the Range Master Pistol Instructor Development course, as I stated before. That's something I've been trying to get into for years. Just hadn't shaken out. And I will tell you, Tom Givens is an incredible instructor. I learned so much more than I thought, and I knew I was going to learn a lot. Folks in the audience, if you have an opportunity to train with Tom Givens, you need to do it, because you will leave that class with so much knowledge, capability, and I think one of the biggest aspects. And Aaron, you're likely to agree with this because you were the first of the Evo Set crew to train with him a couple of years ago. The why we carry that he provides, the mindset, the command of statistics, and giving you the understanding of why you need to carry all the time is one of the best aspects of that class. But I will tell you, folks that know that course, it's pretty tough. It's not a gimme class. I think Tom says that the washout is about 15%. So, folks, unfortunately, that may go in and not meet the standards, but that's okay. It's like, if you didn't meet the standards, go back, So I think there's definitely something to learn if a class doesn't have tough standards, doesn't test, then it's not near as valuable. But that said, man, I'm kind of glad it's over, Aaron, to be honest with you. I was getting a little bit stressed about it for some reason. Again, I guess that both performance stress and I knew it was a tough one, and man, I'm glad to be done with it, frankly.
Well, I saw your scores on your certificate, man. Those were awesome.
Well, I appreciate it, Aaron. You know, folks in the audience, you have to pass every test. So there's two qualifications. One of them is the FBI 2019 qualification, and then there's the Range Master qualification, which was a bit tougher, but you have to pass those at 90%. You also have to pass a written test at 90%. So the bar is very high on all the requirements, but it's doable. You know, if a person has a decent amount of experience, you're also learning during the class too. So, you know, you can go in there and have a decent skill set and then learn during the class as well.
Maybe you're running at 80, and then by the end of the class, when you're going to go ahead and do the qual, you're going to get back up there to a little over 90. Is that kind of what you're saying?
Yes, I think that's definitely possible for most people out there. You do have to come with some experience,
sure,
definitely. But yeah, it was an amazing experience, and I have to say, even though my scores were pretty good, there were guys there much better than me. I'd like to give a shout out to Chris LaPrey. Man, awesome sheriff's deputy. He's actually a lieutenant with the Pinal County Sheriff's Office. I met him 10 years ago when I took the first DCQC, and that was when Cecil Birch, folks have heard him on the show, Immediate Action Combatives, awesome, incredible dude. He was there. Obviously, he was the host of this class. It was awesome hanging out with Cecil again. And just a superb time. Anybody knows you go to classes like that, it's such a camaraderie development. But back to Chris. Chris was vying for the top shooter. He got edged out a little bit, but not by much, by a gun sight instructor, Eric Jahouse. If I've got your name wrong, I apologize, brother. We're going to have you on the show. We already talked about that. But Chris, incredible dude. I really enjoyed learning with those guys. So with that said, man, I think I don't want to spend too much time on it because we're gonna have Tom on the show to debrief that. But Aaron, do you have any questions about the class? Anything you were thinking about?
Well, I just have to say that I will take that class very soon. Hopefully, in the next 6 months. I need to see when Tom is offering it somewhere close to me. But I just kind of have to say, in general, when you go to these high quality classes like a Tom Givens, Paul Sharp, Craig Douglas class, it is actually the funnest time you're going to have in a long time. I can say that the classes that I've taken recently in the last several years have actually been the funnest time that I've had. It's just, just when you're there with world-class instructors, the knowledge and the fun is palpable. So I just wanted to encourage our audience members. These instructors that we have on, we choose to have on whom we consider the top instructors that you can go to. So anyone that we've had on this show, search them out. If they're in your area, go take a class because you will not regret it. That's all I have to say, Eric. But yeah, I'm looking forward to taking Tom's instructor development course too sometime soon.
Well, Aaron, I'm glad you said that. That was a very well articulated statement. We don't just have anybody on this show, even if they're interesting, neat people, so on and so forth. We have the folks on this show that we believe people are going to get the most out of, and Tom delivers. And again, excellent time. Cecil was an incredible host and just a lot of fun. Like you said, man, it is some of the most fun you ever have, Well, with that said, I also have to digress a second. I, too, did not get to do the drill that we prescribed because I actually had my rifle with me the last time I was out at Brian's range, but I ran out of time because I was focusing on some of the skills that I needed for the range master class. So I was like, I'll get it next time. So we're going to go ahead and prescribe that drill one more time, which I'll have all the details in the show notes. It is the Trident Concepts modified Navy qual at 50 yards on an 8-inch circle. So you can use an IDPA target, or you can use an 8-inch pie plate, so on and so forth. But you have 25 seconds to fire 5 rounds in standing, reload 5 rounds in kneeling, and reload again 5 rounds from the prone. So there's kind of I wouldn't say intricate, but it's a little more intricate than I can get into on the air. But the scoring, you have the 25 seconds in there. You add or take away points for shots over or outside the 8-inch. So again, it'll be in the show notes. So let's get out there and let's shoot that drill this week. I know I'm going to. I'm looking forward to just shooting some carbine this week. I know sometimes we focus so much on pistol, but the carbine's been fun this last couple of weeks. So let's get out there, Aaron. What do you think?
Man, great show with Andrew Branca. So honored to have him on. It's been a great show. You want to call it quits for this week?
Yeah, let's do it, man. Great to see you, Aaron, man. You have a good evening, okay?
You too. See you later.
Bye.